afternoon, everybody. Thank you so much for the great attendance that we have here. It is our honor to have Judges Butler, Mulvahill, Salomone, and Malkinson here to talk about what's going on inside the 20th Judicial District. This is a relationship with the judiciary that we really cherish as a bar association. It's one of our longstanding traditions, and we are so thankful that these four judges have each taken an hour out of their day to come and talk with us about what life is like in their view. So we thank them very much as a bar association for their continued relationship with all of us. And the first speaker is Judge Butler. So Judge Butler, thank you and welcome.
Thanks, Jeff. I'm going to kind of do the boring part of the presentation first, which is outlining the different local administrative orders that have been updated, added, or changed. Some of them as recent as just in the past few days, some of them in the past few months. Some of them relate directly to the pandemic and the practice of law in the 20th right now, and others are a little bit more broad about different changes that have occurred. So I'm going to go through those in a minute. As you heard Kyle say, the preference that we're going to try to do is I'll go through some of those local administrative orders, then I'm going to give a few practice tips from my perspective, and then my colleagues will do the same. As you can see, we tried to get a pretty broad spectrum from the bench. We have Judge Malkinson from County Court. Judge Mulvahill is currently in a criminal rotation. Judge Salomone is in a domestic rotation, and I'm in a civil and probate rotation. So we tried to get pretty much the whole spectrum across the bench to try to give you the kind of different tips, if you will, for practicing in each of those types of disciplines, because they do come with different challenges of their own. At the end of the session, if we have enough time, we'll try to answer as many questions as we can. And as you noted, just write a question in the chat, and if we can get to it, we certainly will. So the most tedious part, but necessary part, is talking about some of these local administrative orders. And I'm not going to just read them to you, but I will give you some highlights. You can always access them through the judicial website. Local Administrative Order 11-102, that's regarding exhibits. That was just updated on February 8th. But it's really nothing that's too earth-shattering. If you're the plaintiff or petitioner, use numbers. If you're the defendant or respondent, use letters. The court does not maintain any oversized exhibits. And it's basically about maintaining exhibits and what the court does and what your responsibility will be. Local Administrative Order 20-107, of course, relates to facial coverings which are required in the Justice Center, also in Longmont Courthouse for any court and probation services. Local Administrative Order 20-108 is the FED, procedural rules, forcible entries and detainer. And if you do that kind of work, there are limits in the number of cases that we are even accepting. The cases have to be filed by the Wednesday 10 days in advance of the Friday return. And there's a cap in the Justice Center for a weekly cap or limit of 25 cases that can be filed. And that includes up to 5 pro se cases and up to 20 law firm cases. No one law firm can file more than 10 cases in any given week. In Longmont, there's a weekly cap of 10 cases that can be filed. 4 of those can be pro se, and no individual firm can file more than 3. There's also requirements about having an affidavit attached, making sure that you provide the eviction prevention services and eviction mediation services and other materials to the tenant. There's also Local Administrative Order 20-109, which relates to certain limitations on debt collection practices. And that gives you some guidelines on how to comply with those for any of you folks who do debt collections. Local Administrative Order 20-110, resumption of jury trials. That was last updated on January 11th. Criminal jury trials are suspended until March 1st. Civil jury trials are suspended until July 19th. Court trials are still permitted. I'd say that we had a similar presentation in December, and I keep focusing on that for any of you folks who perhaps may have shunned the idea of a court trial in the past, whether it's a civil case or otherwise, but maybe you want to consider that at this time to see if you can get your case tried a little bit sooner. Of course, there is a backlog now that we've been in sort of this lockdown for almost a year now, and it will continue to grow until we resume the jury trials. Local Administrative Order 20-111 is the eviction moratorium. That was last updated January 8th. And due to the CDC and the DHHS orders, there's a local order now temporarily halting residential evictions by reason of non-payment through March 31st, 2021. And then if there is an FED proceeding filed, there are some procedural things you do need to follow. Local Administrative Order, another new one, 20-113 regarding the electronic audio recordings of court proceedings. That was just updated February 8th. As most of you know, we use the FTR recording device for the record, in case you ever wonder what FTR meant, but FTR recording device. As a result of the state budget cuts last year, the 20th Judicial District cut all of the court reporters. And so the FTR has been the device for any hearings. In the past, we used court reporters in a priority, but now we don't have any. And so there is there's a couple of local administrative orders related to that. 20-113 relates to how to get a record, a copy of the disc, transcript, things like that. And local administrative order 20-114, which is also brand new, talks about how parties and counsel can, if they come to agreements, have court reporters for their trials and hearings. But it does require agreement of counsel, but you should review that. It even includes things like if both sides agree they want a court reporter, but you can't agree on which reporting firm, guess what? You're going to use the FTR then. And there's also requirements that the court reporters provide real time for the judges. And I realize that some folks may want court reporters for other reasons besides just getting a transcript, but you may want daily copy. You may want it for other purposes as well, having the real time, the actual testimony popping up in front of you on a computer screen. So if parties can agree in certain trials, you can certainly have those, but it does require that counsel actively confer and come to agreements, because if not, the default is always going to be the FTR. And it also has to do with what becomes the official record. So let's say counsel is using a court reporter, even remotely, so they can get daily copy, et cetera. And then there's an appeal. If the court reporter was not approved as being the one agreed to by parties and become the official record, the FTR is still the official record, regardless of what you got from the court reporter. So as you've now heard, there've been just quite a number of updates and changes to these local administrative orders. And it is important that you look at those if you're about to try a case or you have a case coming up and you're not quite sure what a particular practice is in the 20th Judicial District. I have a few tips of my own that I wanted to share, and then I'm going to ask my colleagues to start weighing in on their particular tips, particularly with their practice areas. As I said, I'm currently in a civil and probate docket, but as most of you know, at least from the faces I see, all of you practice here pretty regularly. Because of the trailing docket, we can all be assigned any kind of trial: criminal, civil, juvenile, mental health, probate, domestic relations, etc. So as you guys know, the virtual courtroom information is on the state judicial website. So each judge has their own room, right? It's a list of numbers. When you sign into WebEx, each judge has their own room, and that's what you will be signing into. But it's important to look at the notices. So for example, let's say Judge Mulvahill had a hearing scheduled and the notice has gone out, but there's a last minute change. You want to make sure, to me, let's say, you want to make sure that you're signing into the correct room. So make sure you look at the most recent notice or amended notice of the hearing to make sure that you enter the correct room and that you give that information to your clients as well as any witnesses. It really helps in this age of remote practicing to upload your exhibits ahead of time and to not waste both time and money. I really want you to actively confer to see if you can agree on a set of stipulated exhibits. If you cannot, well, then you can each file your own, but it really just becomes time consuming and costly if the court is looking at Exhibit 1, which is the same as Exhibit C, but we have to prepare for these hearings without knowing that. It also helps to identify your exhibit when you upload it. Instead of just having Petitioner's Exhibit 1, maybe have Petitioner's Exhibit 1, Petitioner's Sworn Financial Statement, or something like that, that identifies what it is. It's a lot quicker and easier to find during a hearing, and it's even easier for counsel as well as any witnesses. Make sure you speak slowly, loud enough, and clearly to get it picked up on the recording device. When you're in the courtroom, we have signs that say speak within 16 or 18 inches of the microphone. When you're remote, we don't have that. And if you're kind of moving away from your computer or you're moving around, it may not get the audio like you want it to. So do your best to speak close enough to the microphone on your computer or your smartphone or whatever you're using to call in to get picked up on the recording device. As usual, make sure only one person speaks at a time. Try not to speak over each other. Spell any unusual spellings so that if we do need a transcript later, it helps the transcriber. We seem to have some issues with internet connections from time to time. And if you've been on a hearing where a yellow triangle appears in the top corner of the video, that usually means somebody has a poor internet connection. So to the extent that you're not sure if yours is good or your witness or your client's is good, and if it's a district court case, you can usually ask a law clerk ahead of time. And I don't mean the day of the hearing, but ahead of time to try out any technology to make sure you have a good solid connection, your audio works, your video works, etc. You are not permitted to record any session unless you're given permission by the court, and you should advise your clients and witnesses of the same thing. And as I mentioned earlier, the FTR is the official record of the proceeding unless you have that court reporter situation where both parties have agreed and you've agreed on the same reporting service, etc. So maybe I'll turn it now over to Judge Malkinson and he can give us some county court perspective of what you guys are seeing and what's helpful for the county court judges.
Thanks. So I guess the first thing I wanted to say is the thing that's probably most dynamic right now in county court, as far as the administrative orders that Judge Butler was just describing, is the FED court. We've revised the administrative orders a number of times over the course of the pandemic so far, as a CDC moratorium took place, and then there was a Colorado moratorium from Governor Polis, but then that moratorium expired, and then the CDC moratorium got extended yet again. So the FED docket is probably the one that, if you're a practitioner in that court, is unfortunately the most confusing and challenging, because we keep revising the FED docket. The other thing that happened in Boulder, the city of Boulder, not yet the county, but the city of Boulder, is there was recently an ordinance passed that allowed tenants, all tenants, to have access to a free lawyer. So our dockets on Friday mornings, which is when we do our FED docket, now have all tenants have the ability to meet with an attorney. We've, as Judge Butler noted, we've limited the number of evictions in total to limit the number of people arriving in the courtroom. We've limited the number of people in the courtroom on our eviction mornings to 10. So sometimes there's a little bit of shuffling on those mornings. We're starting to allow remote appearances for the eviction docket, which we weren't previously doing. That is in part to expand access to justice, in part due to COVID, and in part due to an attempt to increase the number of filings we are allowing. But that is, if you don't normally prosecute or defend evictions, that's probably the one that would be a little more tricky, because I think every 2 or 3 weeks we're having to revise the administrative order as far as what the moratorium is or is not saying. As far as the regular dockets, for criminal, everything we do is remote except preliminary hearings have been in person, motions hearings are in person, and returns for filing of charges at the jail are in person. When it comes to the returns of the filing of charges at the jail, District Attorney Doherty has made a blanket statement that he does not oppose motions to have remote appearances at the jail for filing of charges. That would also be true for hearings on advisement. I'm looking at the list here, and there's a number of people who have already filed those motions. I know it might be frustrating that you have to file a motion, but there are certain cases where, for a variety of reasons, we might want the defendant present in person at the courtroom, at the courthouse, at the jail. Nevertheless, we routinely and probably 99% of the time grant those motions to appear remotely for hearings on advisement and filings of charges. We've done the majority of preliminary hearings in person, but when good cause is shown, we've allowed appearances remotely. And the only people so far on the preliminary hearings that I've conducted since COVID, the only people who have appeared remotely have been defendants. And when a defendant has requested to appear remotely, then I am doing so with the express advisement that you can't challenge the ID procedure because you're not in the courtroom, or challenge your ability to confront due to the remote appearance. There might be other challenges to your right to confrontation, because I limit cross-examination, and that's fine. You can make that argument. But when it comes to your ability to challenge ID procedure, if you want to appear remotely, you can't appear remotely and then say, well, it was a crummy ID procedure because I was on the computer. But most of our preliminary hearings have been in person with live testimony. As far as the rest of the cases, we're pretty flexible when it comes to whether or not we would allow a remote appearance for a small claims case or a county civil trial or a permanent protection order hearing. And it's really on a case-by-case basis if someone's able to show good cause to appear remotely. For some of the small claims cases, which I know most of you would never appear on, but occasionally might, mainly the reason why we would or wouldn't require someone to appear in person would be their ability to post exhibits and upload those ahead of time. So we've actually had a lot of our small claims cases in person. The one thing I want to say about the criminal docket that we're encouraging is administrative continuances. If there is a docket, and obviously, as you all know, we have large criminal dockets, and if there's a docket where all parties know all they're going to do is ask for a new date, then we've regularly granted administrative continuances by email. We make a clerk note in the file, and we get a new date with all the parties. As you've probably all heard a million times since this started, if there are sound issues, one of the things besides logging off and logging on again that we've noticed is simply turning off your camera, and then usually that will increase the sound issue. So I think those are the things in county court that are probably most notable about what are in person and what are remote. So far, most of the people who are appearing in person on the criminal dockets are out of custody defendants who might not have access to a phone or might not be quite as organized in being able to log into some sort of WebEx device. And those are the people who we are calling those cases first. And anybody who's been on one of my criminal dockets knows that I'm always getting the people who are in person in the courtroom out of there before we do anything else. So I think that's it for county court. And of course we could take questions at the end.
Judge Mulvahill?
So the district court criminal divisions are conducting the arraignment dockets. Probably about 98% of those are being done by WebEx, all counsel and the defendant. And we encourage that, and we expect that practice is going to continue until such time as the 6-foot social distancing requirement is removed. It's certainly a public safety issue, but it's also a practical issue in terms of the size of our courtrooms, and particularly my courtroom in L. And if you have a question about whether or not you and your client need to appear in person or not, the presumption would be you can appear by WebEx for an arraignment. If you want to appear in person, we're allowing you to do that. I try to follow the same procedure that Judge Malkinson does, and that is if you're in the courtroom in person, I'm going to try and move you out of there as soon as I can. But if you want to appear in person, of course, you're welcome to do that. Much like county court, evidentiary hearings are presumed to be in person. All counsel and the defendant and all witnesses, unless the defendant agrees to conduct the proceeding remotely and submits a written agreement and waiver. But that's not anything that's come up other than, I think, once. The administrative continuance procedure is really encouraged. What you're going to see if you sit in on a docket day in and day out is that a significant portion of the docket is continued over to another arraignment date. And that's not anything that Judge Sierra or I have any heartburn over, particularly given the current circumstances. But if you know ahead of time that you're going to want to continue your arraignment for a period of time, talk to the prosecutor, see if they'll agree. And if there is agreement, just based on the conferral, you can call my CJA and just say, hey, we've agreed to an administrative continuance. Can you give us a new date? And nobody has to appear on the currently scheduled date, and she'll give you a new date. Occasionally, counsel will file a motion, sometimes last minute, give my CJA a heads up so I can look at it and get it ruled on. But I think you'll find that 99.9% of those are going to get granted. One of the issues that we're running into repeatedly is where we need interpreter services for non-English speaking defendants or victims or witnesses. And if you have a client who needs interpreter services, we're going to try to direct you to remote simultaneously interpreting, which is still set up by our interpreter's office, primarily through Mike Bush. And what that allows is a separate phone line from the interpreter to the non-English speaker. So the translation services can be provided simultaneously with the other person speaking. And it avoids that back and forth and that interruption, which frankly on a WebEx hearing is really difficult to manage and to focus on. But if you have a non-English speaking client who needs interpreter services and we direct you to RSI, take a look at it ahead of time and practice with your client once or twice. I just had a hearing this afternoon where the non-English speaking defendant couldn't connect. And I think it was a simple matter of just not understanding where to call. But if there had been better preparation, I think we could have avoided the 15-minute delay and obviously some frustration for everybody who was involved in the hearing. Judge Butler already mentioned the, oh, here comes Judge Salomone, who's supposed to be in her courtroom. Apparently she was technologically challenged. So I'll pass my iPad over to Judge Salomone as soon as I finish and you can hear from her. You can sit in the comfy chair. So Judge Butler mentioned the administrative order 20-112. And basically it provides for criminal trials, they're suspended until February 26th. The next sentence says trials will resume March 1st, 2021. I would simply tell you that administrative order remains in effect, but the chief judge and a number of administrators and I are talking with Boulder County Public Health on a regular basis, at least weekly, asking them to review and let us know if the plan that we put together back in the summer is still viable under the present pandemic circumstances. We are not pretending to be epidemiologists or public health professionals. We are relying on the advice of Boulder County Public Health, and we are talking to them regularly. And I understand, I really do understand the concerns that have been raised by a number of members of the bar about resuming trials on March 1st. And all I will tell you is that we're relying on the public health professionals, the people that are trained and have been handling this for 10 months, and we will follow their direction. And that's about all that I had, because the WebEx procedures for a remote criminal hearing are the same as Judge Butler and Judge Malkinson talked about. So let me turn this over to Judge Salomone, and she can update you on the domestic docket for the 20th in the times of pandemic.
Well, while they're making the switch, I wanted to add something, because I know Judge Mulvahill mentioned social distancing and spacing. And for anybody who has previously been in courtroom I, which is Judge Sierra's courtroom, and I had that for a couple of years at one point. No, it's a kind of a terrible courtroom to do criminal trials in, or even really a large docket. But I don't think I'm speaking out of school. We all have received Judge McDonald's notice of his retirement at the end of March, and I believe it is Judge Sierra's intention to move over to take Judge McDonald's courtroom, which is much larger and can accommodate quite a number of more people, number one, and two, there's not a couple of pillars in the middle of the courtroom that block people's views, etc., which means the lucky new judge will be in courtroom I, which is almost like a rite of passage, I suppose. But I wanted to mention that because that will help, I think, with both folks coming into the courtroom when that's a little bit more relaxed, or even the ones that are still coming in now, whether it's for particular hearings, etc. Judge Salomone, who is also known as Judge Mulvahill, will now tell us from the domestic relations standpoint about those WebEx tips and practicing during the pandemic.
Thank you, Judge Butler. I feel like I am the living, breathing cautionary tale of all WebEx woes. I swear it was working this morning. As many of you have said to me in hearings, Judge, I swear it was working this morning. So I swear it was working this morning. So the bad news is that I have missed the majority of the things that my colleagues have said, and I don't want to waste your time by repeating things. I will tell you that I'll take any questions that you have. The main thing that may have changed since the last time that many of you regular DR practitioners attended one of these similar presentations is that we have moved as a DR group all hearings are presumptively by WebEx until March 31st. There is really no magic to the March 31st date. We just tend to re-examine the state of the pandemic on a quarterly basis, and also understanding how far out our dockets are mostly set. We try to review and choose a new date, or else go with the existing date with at least 2 months or so to spare, so that people aren't scrambling and they know how they're likely to be presenting a case in the DR courts. And that includes both Magistrate Hanselman, Magistrate Collins, who in O is now doing some DR just to help us with some of the volume, and the 3 DR district courts, which are 1, 12, and 14. The other thing that I want to make sure that I've drawn attention to, if you all haven't seen it already, is that on the district court division, District 20, there are a number of procedural orders that the judges have posted. I know that myself and Judge Labuda have posted procedural orders that are online on our various judge courtrooms, the same place where you can get the dial-up information for your hearing. The procedural orders we sort of modify on an as-needed basis, intended to address some of the issues that we see recurring in DR cases. So if you look at the procedural orders that I believe are almost identical for myself and Judge Labuda's courtroom, last time I looked, Judge McDonald hadn't posted one of his own, but I think it's fair to assume that what Judge Labuda and I have posted also would be what he would want. But there are essentially some tips that are generated from the things that we keep seeing as being issues in DR cases. So if you look there, I think that you have most of the information together with what the other judges have said that you need.
Salomone, would you address how you're handling PPOs, whether those are in person or remote? And if they're remote, how are you handling service on a person who is restrained?
They are mostly remote at this point, and the division is asking when the TPO is granted and the PPO hearing is set. We are asking verbally through my CJA, if the CJA speaks to the parties or the order itself says, file the service that demonstrates the proof of service into the ROA. If people are getting service through the Sheriff's Department by way of law enforcement, the Sheriff's Department is actually filing the service into the judge's ROA, so the party doesn't have to do that. But if it's an out of immediate location, outside of Colorado location, then the expectation is that you would file into the ROA the proof of personal service prior to the hearing. In contempt motions in DR courts, we are actually vacating contempt advisements that don't have service filed prior to the advisement date coming up. For PPO hearings, we're not doing that. By that, I mean that if there isn't service filed, the judge will still come on the bench and get ready to hold the hearing, and then we'll address with the parties the existence of the service issue, because a PPO is a safety-based proceeding. But understand that if you file a contempt, and the contempt also requires personal service, and you don't serve your personal service into the Register of Actions electronically before you start the hearing, you are likely to lose the hearing the day before, because the clerk will check and see that there is no service and therefore vacate the hearing.
And how are you handling contempt sentencing? Are those in person or are those remote?
They are presumptively remote. Everything in DR at this point is presumptively remote. We have been, I think all the divisions have worked with parties who cannot proceed remotely because they literally do not have the technology, but that is the rare case. And so everything is presumptively remote at this time and through March 31st.
Judge Malkinson, could you respond as to how county court's handling the PPO issue with regard to in-person or remote and the service issues, as well as addressing a couple of the FED-related questions that came up on the chat? You're muted. You're still muted.
Okay, there we are. So for the service on the PPOs, it's the same thing. Most of our TPOs that come in are in Boulder County and are served by the sheriff, and the sheriff uploads them. If it's an out of county or out of state return to service, then the petitioner is required to file it. And we are, unlike Judge Salomone, we're presuming that our PPOs are in person. And if there's a motion with good cause, then we'll hold PPOs on virtually. But for most of the judges in county court, we've done very few virtual PPOs. We've done them, but primarily they're in person. And let me look at the chat. Okay, so the bar has authorized Bruce Weiner to announce that Bridge of Justice is the one, the group providing the free legal defenses that I described earlier. Attorneys do not need to request to appear remotely for FEDs. Starting tomorrow, for the first time, we're going to just have FED, the virtual courtroom, available for FEDs, and any parties can log in, and we'll have to do breakout sessions for mediations and for tenants who arrive in person and need to speak with their attorney or somebody else. There's another message on FEDs. County court returns in civil cases handled the same way. No, we have not limited the returns in civil cases. Were there any other questions about FED?
Judge Malkinson, with regard to the number, the limit on the FEDs, is it just the first X number that come in that get taken, or how are they prioritized?
So I'm not sure how the firms have made their decision as to which, for the firms that are limited to 10 apiece, as to how many that they file. It seems that from informal conversations we've had off the records, that they're just prioritizing which cases they are filing. If the virtual docket seems to be successful, then I think we're going to expand the number of people. We're just trying to limit the number of people in the courtroom because of the 6-foot social distancing. And that is why we have limited the number of filings. And I'm sure it's frustrated some landlords that we've done so, but for a variety of reasons, including the moratorium on the limitation of evictions for non-payment of rent in certain circumstances, it seemed like an appropriate number that we will expand when we think it is safe to do so.
There's another comment with a question at the end regarding, well, I'll just read it. I have participated in 2 contested proceedings that involve the presentation of exhibits and witness testimony since COVID-19 limitations went into effect. I do not believe WebEx or Zoom provides an adequate substitute for in-court proceedings, but I am practical enough to know that WebEx and Zoom are likely here to stay, and I'm curious as to how our judges believe these tools will be continued to be used once the pandemic restrictions end. I'll give a quick response and then let my colleagues weigh in. In some ways, the pandemic has opened up a number of avenues of folks being able to participate in the court system less expensively and more easily than they might have prior to the pandemic requirements of virtual presentations. I've done a number of dissolutions where people are sitting in a car outside their workplace with their phone as their audio and video, and they likely would have had to take a whole day off of work, but maybe only had to take a couple of hours in a smaller case or an easier case. But although we've had sort of discussions about what might happen, we don't know to what extent the virtual or remote presentations will continue yet, or whether or not we will continue to allow it past the time when the health folks, the public health folks, remove the social distancing, mask requirements, limitations on gatherings, etc. But it certainly has proven to have some upside for allowing greater access to justice, if you will, or greater access to the court system than we had before for some folks. I agree that the WebEx platform has its limitations because we do run into problems, technical problems or other problems from time to time. But ultimately, as you all know, I don't get to make those decisions, but I'm sure there'll be folks weighing in on that at the proper time. Judges Mulvahill and Salomone, do you want to weigh in on your thoughts on that? And then we'll have Judge Malkinson. Tell Mulvahill he can't just sit in his comfy chair and not participate now.
He's sitting in his comfy chair and he's authorized me to say no. No, that is true, but I think that the reality of the situation is that from my perspective, and I'll let Judge Mulvahill jump in if he wants to, the task of just trying to figure out how we are going to do today and next week has been so all-encompassing that, at least speaking on behalf of the DR division, we really haven't had serious discussions about what we will do when we have choices. We're just really trying to manage the needs of the day that day. Do you want to add anything, Judge Mulvahill?
No, but I agree with the attorney who made the initial observations.
Judge Mulvahill says that he agrees with the observations in the comment and that he doesn't have anything else to add at this point.
Judge Malkinson?
We haven't explored exactly what it would look like when everything, as Judge Butler referenced, goes back to normal in the sense that we don't need to socially distance and don't need to wear masks. I can say that the one thing that I would hope continues is when it comes to in-custody appearances for people who are out of county or in DOC, it's a tremendous amount of work to get somebody to go to Crowley, and a deputy to go to Crowley, pick up a defendant, bring them back to the jail, and then they have an arraignment where they get their case continued again. So for those types of appearances, I would hope, this is certainly not in writing or anything anyone's agreed upon, I would hope that for those out of county and DOC in custody defendants, that we would find a way to be able to continue using this for continuances and hearings of a certain nature. And then I also think that given the way some of these WebEx dockets have gone, and you can so easily continue a case, that also might be something that we could contemplate seeing in the future, is a quick continuance via WebEx. But I wouldn't, if I had my preference, I would never do a sentencing again via WebEx if I could help it.
There's a comment with a question or a request for a comment. Can you comment on the size of the backlog of cases needing juries? And do you imagine this will bump existing trial settings or just cause delays as those begin to schedule in? The reason there was a change or a difference between the resumption of criminal jury trials versus civil jury trials is in part because of the large number of criminal jury trials that were bumped and not resolved that will need a jury. And once things are loosened up, we can go back to having multiple felony jury trials done in the courthouse. The problem we had when we tried to do jury trials even in December for a short time was we could not handle more than one felony jury trial in a week because of the number of prospective jurors that would be in the courthouse and the requirements to comply with the social distancing, et cetera, requirements. So Judge Mulvahill maybe can weigh in on the actual numbers. I'm not sure what those are, but I know it's getting worse and worse, or bigger and bigger, if you will, because cases haven't been tried and they're not all resolving as much as we'd like them to. Sometimes cases just can't get resolved. Judge Mulvahill?
So the between the two criminal divisions, we've got over 150 jury trials set within the next 6 to 7 months. And, you know, the number keeps growing every day. And even if we were to restart jury trials on March 1, we're going to be able to try one case a week at best for a significant period of time. So the concerns raised by Mr. Staley in his question are legitimate, and we're brainstorming how to do as many trials as we can as soon as we can, but we're hamstrung, and I don't see the dilemma getting any better anytime soon.
There's another question in the chat, Judge Mulvahill, about whether there have been any discussions in the 20th or statewide on holding remote jury trials. You know anything about any discussions there?
Well, I know that the state has a working group that is exploring virtual jury trials. I don't think they've gotten as far as even putting together a rough plan about how to do that. But I think everyone understands, or at least they should understand, that that would apply only to non-criminal cases. I don't, just speaking for myself, being the legal scholar that I am, I don't see how we could conduct a virtual criminal jury trial without violating a number of constitutional rights. And that's a prospect that I don't think anybody's even suggested.
Well, in addition to that, there have been, you know, issues raised, certainly mostly by public defenders, but other defense counsel as well, about constitutional issues related to the pandemic and speedy trial. And I suspect this would just add one more layer of appellate issues if somebody considered doing that. And until we receive some sort of affirmation from the Supreme Court as to what might be constitutional or not, I don't think you want to be the test district that tries these things and then ultimately 2 or 3 years later has to retry every one of these cases if it's ultimately determined to be unconstitutional. Judge Malkinson, how about in county court? Can you talk a little bit about backlog of jury trials?
The only thing I can say is we have a backlog, and we're going to have the exact same limitations. It's slightly different than district court, but it's going to be one a week for the foreseeable future, one in Boulder and one in Longmont. And hopefully we'll be able to expand that as the public health instructs us that it is safer to expand it. But until then, we have a backlog, and that's just the situation we have.
For folks who are able to go on to different websites to try to get in queue, if you will, for vaccinations, hopefully you've all looked at the public health guidelines of sort of prioritization. And it looks like the great number of the public, which would include most of you folks too, unless you're over 70, work first line of health, etc., is probably not going to be until sometime in spring or maybe early summer. And so all of those things, I'm sure Chief Judge Bakke and Judge Mulvahill and the different administrators and the public health folks have been considering every time. And I know they've met many times, and it's a constant upgrading and updating each other. So I know they're trying to keep everyone safe and healthy. And it's a rub to try to figure out, can we get these cases done, and how do we keep people safe? And although we don't have a perfect answer, I know the priority is to keep people safe while trying our best to keep cases moving through the system of all types. And because domestic, of course, is nothing but court trials, I don't know if the numbers have gone up or not in terms of trials, but I know that, as you guys know from the trailing docket, the civil divisions have received a lot of overflow of domestic trials on the scheduling weeks, although I've also done several civil court trials, as well as termination of parental rights and some mental health. Judge Salomone, can you speak to whether or not the case numbers or the trial numbers are going up, down, or staying about what they were pre-pandemic in the domestic dockets?
I cannot speak to the numbers, but I can tell you that in terms of how far we are setting out and the existence of a backlog, there is no backlog in DR. And anecdotally, I would say from myself and Judge Labuda and Judge McDonald, we are setting at about we are offering settings out just about as far as we were pre-pandemic. It took us about 4 months, I would say, to recover from the time that we lost from March to June. And by the middle of the fall, we were just about back to moving cases the way that we did pre-pandemic.
There's a question from Mr. Harrison about whether judges have gotten vaccinations, have DAs gotten vaccinations, or are there schedules for when judicial department employees do get them under the current phases? The answer with regard to the judicial department is, as of February 8th, just Monday this week, we were eligible under that, I think it's 1B2 or 1B1, whatever it was, phase for being judicial employees. And that includes not just the judges, but the clerks, the CJAs, those folks who are working with the individuals who do come into the courtroom. And so I don't know of which judges have actually gotten vaccinations. I know a lot of us have tried to access certain websites. Nobody's showing up and saying, let's vaccinate all the judicial folks. You got to still do your own thing. And whether it's through King Soopers or some other pharmacy, try to find a slot to get a vaccination. As far as the DAs, I don't know the answer to that. Maybe Judge Mulvahill knows, but there's no set schedule or not, unfortunately, and that's mostly because the logistics were not put into place, I guess, from the folks at the top of the chain down to the bottom. Judge Mulvahill?
So I understand that both the district attorney's office and the Boulder Public Defender's office have gotten scheduled for vaccines. I think one of them was supposed to start today. But at what rate they're going to be vaccinated and what percentage are actually going to take the vaccine, of course, nobody knows. But so I think that answers the other parts of David's question.
Any other chat questions before we wrap up? We've got about 4 minutes left. If not, I do want to thank everyone. I always feel like we preach to the choir when we do these kinds of presentations. It's usually the folks who are already on top of things, who already are diligent and already follow the rules. But it's all tell your friends, tell your family, and try to spread the word, if you will, about any of these things that might help you to help us to make a case go more efficiently and perhaps get it even in front of the court a little bit quicker. Judge Malkinson, any final comments?
No.
Judge Mulvahill?
Just everybody stay safe.
And Judge Salomone?
She says the same thing.
Thank you very much for attending, folks. We appreciate it. Have a good evening.
Excellent. Thank you, everyone. Thank you to our judges again for being able to present tonight. Thank you, everyone, and have a good evening.
Thanks, Kyle.